First of all, just want to welcome everyone and thank you for joining us for today's presentation. My name is Shannon and I'm part of the Community Engagement and Events team at Russell Alexander Collaborative Family Lawyers. I'm going to start with some introductions and I will let you know what's on the agenda for today before passing things over to our speakers. And just a quick note that you'll notice that the chat box has been disabled, and this is just to make sure that everyone stays anonymous to other attendees. But if you do have any comments or questions for our team, you can send them through the Q&A box, or you can also email me at shannon@russellalexander.com. I'll make sure to put my email in the chat for your reference as well. And we also just please ask that you keep in mind that this presentation is intended to provide general information on the topic of divorce, parenting, and self-help in family law, and should not be considered as legal advice. So to let you know what's on the agenda today, in this 1-hour presentation, our panelists will be discussing the following topics in regards to divorce, parenting, and self-help. They'll be covering the basics, what is self-help, we're going over status quo, the good, the bad, and the ugly, and also covering some case law on this topic as well. And at the end of the presentation, we'll also have a dedicated Q&A segment. So if you haven't already, please feel free to submit your questions, like I mentioned, through that Q&A box, and we'll do our best to get to your question during the presentation. We'll also be providing links to resources mentioned that in today's presentation and a follow-up email tomorrow, so you can keep an eye out for that. And so without further ado, it's now my pleasure to introduce today's hosts from the Greater Toronto Area. We have Margie Primero-Pimentel, Cindy Vergara, and Russell Alexander. Margie has over 15 years of experience in family law. She is a collaborative family law practitioner and an accredited mediator who is passionate about facilitating fair and reasonable settlements for her clients. Margie approaches law in a holistic manner and believes that as a family lawyer, she has a unique opportunity to provide emotionally intelligent advice to clients that will assist them in moving forward with their lives in a better position with the best interests of her clients and their children in mind. Cindy is an associate lawyer at our firm where she practices in all areas of family law. Since being called to the bar in Ontario over 10 years ago, Cindy has been practicing exclusively in family law and is passionate about supporting her clients in achieving goals quickly and effectively in a cost-effective manner with the objective of implementing strategies that are unique to her clients and their goals. For instance, after an out-of-court settlement failed, she vigorously advocated and won an international jurisdiction motion wherein a young child will be attending school in Canada as opposed to a foreign country. Lastly, we have Russell, and Russell is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell uses his knowledge and expertise in collaborative family law with a client-focused approach by creating unique solutions for each of his clients. So now that you know a little bit more about our team and what we have on the agenda for today, I'm going to pass things over to Russ to get started.
Well, we have a teaser too, right?
We do.
So should I stay or should I go? Implications when a spouse leaves the matrimonial home is our newest ebook. We're going to give it away to qualify at the end of the presentation. Shannon's going to let you know. Please put your questions into the Q&A box. We love getting questions throughout the program. We're going to do our best to answer everybody's questions. We have lots of questions that came in ahead of time. Also, we're going to do some polls, so please answer the polls. It helps us understand our audience and it makes today's presentation a little more interactive. I thought Shannon was going to say Russell's from parts unknown today, but can we do our guarantee, Shannon?
Well, so for anyone who's new to our virtual event series, for those of you who have joined us before, you'll know about this, but we always offer a money-back guarantee for our free virtual events. So we hope that nobody wants to claim their their money back, but if you do,
contact Shannon. All right, let's get at it. Let's start with a poll. What is your reason for joining us today? And we're going to leave that up for a moment. You've got a number of options there, but I'm going to throw a question at one of our presenters. All right, here's one for Cindy. If I'm prevented from returning to the home, what about my stuff? So what are clients are supposed to be doing in that situation?
Well, the answer really is it depends. Like what happened? Why are you prevented from returning to the home? Is there a restraining order? Is there an exclusive possession order? Is this a criminal law matter? In situations like this, you're going to want to try to negotiate and come to an arrangement as to when you can return to the property to obtain some of your belongings. So that might require the assistance of the police or a neutral third party.
And if you're entitled to the home and there's no criminal restrictions, you're entitled to be there. But I think your advice or your suggestion is a good one. You're going to want to do it in an organized and civil fashion, right? You don't want to be fighting over the couch or the prints on the stairs to the front door. All right, let's take a look at what our audience poll results are. So 57% family professional, 21% other professional, 16% going through a separation and divorce, and some other doing some research for a loved one. So thank you for participating in that poll. Let's get into it. Margie, you got our first topic here. What's happening? What's self-help? What are we talking about today?
Okay, thanks, Russ. So before we go into a deep dive into the actual meat of our conversation on divorce, parenting, and self-help, we want to make sure we have the basic foundation about these issues. So the Divorce Act, first of all, applies only to married people, while the Family Law Act and Children's Law Reform Act, which are provincial acts, apply to both married and unmarried individuals. So I don't want to confuse anyone, but the bottom line here is that despite the different legislation's applicability depending on marital status at separation, the underlying principles remain the same throughout the legislation, especially when it comes to parenting. So for example, when we're dealing with parenting issues, the best interest of the child remains the primary focus and only consideration under the Divorce Act, the Family Law Act, and the Children's Law Reform Act.
All right. And what about the lexicon of self-help? This is, when we're in court, this sort of has a negative connotation to it, right? At least in my view, if a judge says a litigant's done self-help, that usually means they're prepared to make an order because you're changing potentially the status quo. We're going to get into that. It also usually is followed by a cost order. So if you're in the litigation process, self-help usually has a negative connotation. Would you agree, Margie?
Absolutely. I usually discourage my clients from engaging in self-help because the courts really frown upon that. So self-help, for some lawyers, they encourage their clients, not encourage, but they give them tips on how to engage in that. But there are certain types of self-help that really you should not engage in. And that's those sorts of situations when you take matters into your own hands and, you impose your own will, respecting, for example, parenting arrangements for a child. And that's usually done when there's a court order or a separation agreement, but not always.
Right.
So yes, it's completely something that courts do not like. And they don't like it when parents breach terms of their court order or agreement, especially when those breaches are a result of self-help measures.
And Cindy's going to get into some case law at the end where I think self-help is sometimes a good thing, right? If you're a victim of domestic violence, you need to protect your children. I think I jumped ahead a little bit. Sorry, Margie, I got excited.
That's
let's
okay.
Go back to divorce and separate. I just want to get right into it, but let's lay the foundation before we get too deep into it. Sorry about that.
That's okay. So, so in terms of the parenting time language, if you're not new to our series, you've probably participated in the other webinars where we've gone over the changes in the Divorce Act. But for those who haven't been, if this is a new webinar for you, the recent changes in the Divorce Act and the Provincial Children's Law Reform Act that occurred, I think it was last year. There are significant changes there that relate to parenting. And one of those things is a change in terminology from custody to access to decision-making responsibility and parenting time. So there's been a move away from this proprietary ownership language of the old act, of custody and access, and a move towards more language that really aligns with what custody and access actually meant within the family law context. And that's important because it's, again, a shift towards, highlighting a real focus on the children, and which is another expansion of the language in both the Divorce Act and the Children's Law Reform Act, the language and the criteria when considering the best interest of the child. And that expansion includes, most notably, an inclusion of of family violence, the existence and impact of family violence on a parent's ability to parent a child, as well as their ability to properly co-parent with the other parent. So now the primary focus when dealing with parenting issues has been and always has been the best interest of the child, and the changes in the law and the parenting language in the law expands the criteria factors to be considered when determining the best interest of the child. So I think we've jumped ahead to self-help and what that means to each of us, but
if we had to define self-help, there's a question in the chat. First of all, it can occur at any point of your separation and divorce, right? And even after you get your divorce order. But I'm just making some notes. Would it be unilateral action taken by one person without notice or consent of the other spouse? Does that seem like a fair definition?
Absolutely.
Do you agree with that, Cindy?
Yes, I do. And self-help can either be, as explained later on, can be justified or not justified, which we'll get into.
And we're going to spend an hour talking about this, but in my experience, and we're going to jump a little bit to what status quo means, right? Usually when parents separate, that's the most fluid time, because in a lot of families, there's not an agreement in place. There's no ground rules. Maybe both parents want parenting time of the children. So it's very fluid. So let's do our poll on status quo. If we can pull it up there. What exactly is the status quo? Because this ties into whether or not you're doing self-help, I think. And I think it's an important distinction. So this is probably a good place to start. We had a question come in about becoming a certified mediator. We have live events on that program, so Shannon will pass on a link. Another question is, where one party paid for the house and it's removed, how is that not considered theft? Well, you still own the house, right? It depends why you're removed. If you're removed by court order, doesn't mean you can't later deal with that property. What's your take on that one, Margie or Cindy?
Yeah, it's just a temporary arrangement. It could be a safeguard. There could be serious concerns regarding the health and safety of the people, of the children, and that's why one parent is removed from the home. But that doesn't mean you're not going to get. That doesn't mean the home is taken out of the financial division of your assets and debts later on.
Yeah, I agree. One more final, thank you everybody for putting the questions in the chat box. One final question here before we get to our poll results. Can the parties put a temporary parenting time to schedule in place while they're living under the same roof during a separation? Well, it's a nesting agreement, I suppose, is what we're talking about. Do you want to talk briefly, Margie, about nesting agreements and what people do if they're still in the same home but separated?
Yeah, I mean, so you could have the nesting agreement. A nesting agreement is where the children remain in their home. It's just the parents that go back and forth, and they've made an arrangement or an agreement as to when one parent will be in the home with the children and when the other parent will be in the home with the other children. But I've also had situations where the parties have entered into a temporary agreement even while they're living under the same roof, because sometimes it's helpful to reduce conflict. I've had, situations where one parent, is insisting on having the children with them, taking them out all the time, and then the other parent doesn't have any quality time with their child. So in those sorts of situations, it's helpful to have, you'll have the kids in your care. You could do whatever you want to do with them this weekend, and I get to do whatever I want with them the following weekend. So I find it's also helpful, even if they're living under the same roof.
I even had a case where they had a parenting agreement under the same roof. One parent couldn't look after the kids, so the other parent said, okay, well, you can pay me babysitting fees because this
Oh,
is
gosh.
my non-parenting time, right? So it's funny how things play out. But
Yeah.
great question. Thank you for putting the questions in there. Keep them coming. So let's see what our audience thinks about the status quo. All right, set by court order, 0%, established by one parent, 3%. Agreement of both parties, 3%. Clear majority here. Current arrangements that have been placed for a significant amount of time. Well, I think that's exactly correct. So if you're going to change current arrangements unilaterally without notice or the other parent's consent, then you're doing self-help, I think would be a fair characterization. So let's talk about the importance of the status quo, because we can see how the two tie into each other. Cindy, what do we got on this one?
So the status quo, I'm going to step back a little bit and just define it. It can be described as the routine, the environment, the community, the residents, the division of parenting duties prior to separation. So the courts will look at upholding the status quo, except in instances that it's not in the child's best interest, which will be discussed later on in our presentation, or where there is clear and unequivocal evidence that the parties agree to a different parenting arrangement and residence following their separations. And in circumstances where the status quo is created unilaterally by one parent without the consent of the other, the courts will be reluctant in upholding that new status quo.
Excellent. Thank you. So let's go to our next slide, the good, Margie.
Okay, so like Cindy said, the courts will often not want to stray away from the status quo. And what I also often tell my clients is to think of the status quo as like cement, right? The longer you let it sit and be, the more difficult it will be to change it. So there's a long-standing, legal principle that, absent any evidence of material change or absent any evidence that an immediate change is needed, the status quo will usually be maintained until a trial. And because of that, as Cindy pointed out, the courts are very reluctant to make parenting orders at the temporary or interim stage that grants one party, decision-making responsibility, or what we used to call sole custody, or to grant one parent primary residence of the children. And so the status quo could be good for your situation if you want the status quo to continue. And the courts recognize that it is in the children's best interest to maintain the stability of the schedule they enjoyed during the parties' relationship or marriage. Of course, there will be some changes to their schedule to account for the fact that the parents no longer reside with each other under the same roof. But again, the main goal is to minimize the changes for the children after separation. So the bottom line is if you want the arrangement that was in place prior to separation, then the status quo could assist you in obtaining an order, maintaining that arrangement, or alternatively defending against an order that changes the status quo.
If I could jump in, Margie. So we often see these cases, the parents disagree what the status quo was prior to separation, right? It's like, oh no, I was taking care of little Johnny full time, and then the other parent says, no, it was equal, right? So is that a common case where the court may order a nesting agreement?
I find in my experience, the judges, nesting agreement or arrangement is a good alternative.
Where the parents leave the home.
Yes, where the parents leave the home and the kids stay there.
Stay in the home, right?
Yeah, that's a good arrangement, but sometimes it's not possible sometimes parties don't have another place to go, right? That's the problem. Logistically, it's an ideal situation, but for some parents, it's not something that's feasible in their circumstances. What I find, I've had the situation before where one parent wants to establish a new status quo that they think, they're saying is the status quo. Oh, dad never really took care of the kids. Dad was always absent. Dad was always working, or mom was always working. We hear that all the time, but for the most part, because courts and lawyers are not present in your home during a relevant period of time, I think most courts are going to assume that, unless there is clear evidence, like Cindy said, to the contrary, I think most of the time they would try to maintain some sort of status quo, also because they don't want one party to have that strategic legal advantage, right?
Right.
Like I said, cement, it takes months, if not over a year to get a trial. If you have that parenting place in place when you get to the trial, it's going to be slightly more difficult to get that changed at that point.
Good point. Thank you. All right. So what's our next slide have on protective tools? I think this is you, Cindy, right?
Yes. So if you're contemplating taking a self-help measure, you want to give the other parent and other lawyer as much notice as possible. And this is so that they're not going to be calling the police and an Amber Alert is issued.
Mm-hmm.
So with that notice, you're going to try to work towards an interim temporary agreement. As discussed previously, this agreement will be in place while all the other issues in your matter are being finalized for your divorce and separation. And an example of this is the nesting arrangement where, there's so much conflict in the home. The parents agree, let's just keep the kids here. It's so much better for them. Let's just alternate in and out. But as mentioned before, it's dependent on whether the other parents have a place to stay. I believe we have, a poll.
So a poll, why not do a poll, right? Isn't that time?
Mm-hmm.
What does the court consider to be an urgent or an emergency matter, right? So let's say there's a breakdown, you need to go to court and get an order in place. The rules say you need to have a case conference, issue your pleadings. It might be several months before you get to see a judge. You're concerned that a new status quo might be created. So some of the language courts uses, well, if you want a motion prior to case conference, it needs to be urgent or an emergency. So let's see what our audience thinks. And while we're doing that, we've got a question for Margie. Can I change the locks on the home and keep my spouse safe? We hear that all the time, right?
Yes.
Status quo, what are we doing?
Yeah, sometimes the client calls you while they have a locksmith right there. So
you mean you
the
don't
answer,
go out and change the locks, Margie, for the client?
no, I don't. That's not part of my service.
Okay.
But the answer to that question is no, especially if you're not married. So it's a matrimonial home if you're married. And under the Family Law Act, the Family Law Act says that both spouses have a right of possession of the home, this regardless of ownership. So you can't change the locks. That's one prime example of self-help. You should not engage in that because it's really not permitted under the Family Law Act, and there are consequences to you if you do that. I think we're going to discuss that further down later on in our discussion.
That may be the correct answer, but I'm going to play devil's advocate. Let's say, your spouse is gone, hasn't been back for 5-6 months. Do you have a right to privacy at that point? Could you change the locks and then say, if you're coming back, give me notice of when you want to come in and why you're coming in if you need some items? Would that be reasonable?
I think that if there were protection concerns, like if you fear the safety and your safety, and this person has been taken away, there's a restraining order, criminal restraining order has been lifted. Apart from going to court, maybe the immediate solution is to change the locks. A former client of mine actually told me about this lock that you can install that you can then remove. So it's a temporary way to prevent entry. But in that case, again, those sorts of situations, in order to avoid it, it's better to be proactive and perhaps get an order to allow you to do that.
Or for exclusive possession. That's good point. All right, so let's see what our audience thinks. Urgent or an emergency matter? Abduction, 30%. Physical mental abuse, 20%. Financial abuse, 12%. Self-help, lack of notice, 5%. Leaving the jurisdiction, 19%. All of the above, clear majority, 69%. So I think all of the above is the correct answer. Is that what we agreed to when we're preparing for this?
Yes.
All right. So Margie, you mentioned protective orders, which is kind of a nice lead in to our next slide. And this is you, Cindy.
So if you find yourself in the situation, like one of those situations described in the poll, you're going to be having a conversation with your lawyer about bringing an urgent court proceeding and to obtain additional safeguards from the court for your situation. And some of these, and these are in the form of orders. One can be an exclusive possession order, as mentioned previously. That's when the other party can no longer return to the home because you have exclusive possession of it. Another one could be non-contact or restraining orders. So the other party cannot, there's restrictions regarding how that other party can contact you and your child and how close they can come to you. Then there are restrictions that can be placed on this parent's parenting time. So their parenting time could either be supervised by a neutral third party or held at a supervised access center. And then there are orders that contain police enforceability clauses. So what this means is, say for example, the parent, the other parent does not return your child at the end of their parenting time. You can then take this court order, go to the police station, and the police will now have authority to locate your child and return your child to you. But they do need those police enforceable orders present. We have the next slide there.
Just on that. All right, quick question here. It kind of ties in. Is the status quo established by police without evidence or investigation? Well, it's not that simple. You got to go to court and get a court order and lay out exactly why you're seeking that relief that you're seeking. Go ahead, Cindy. Sorry to cut you off.
Oh, I think we're on the next slide here to help reduce conflict.
Oh, yeah. So that's right. So you don't have to go to court. What else can we do, Margie? You're the peacemaker firefighter, right?
Yes, I am. So sometimes self-help, when it's justified, again, we're going to go into greater detail later on when self-help is justified. In general, it's not, but in certain circumstances they are. When it is justified, it can really help reduce conflict between the parties. For example, if one party is having a difficult time processing the divorce, for example, time apart will help reduce that conflict. And it will also help minimize the amount of conflict that the children witness. So what are your thoughts on that, Russ? How do you think the self-help helps reduce conflict?
Well, I think it's a great idea, especially if both parties have counsel, right? You may not get an agreement on everything, but maybe you can get an agreement until your first meeting date, right? And have a meeting 2 weeks out. So let's come up with some ground rules to get us through the next 2 weeks. And then you agree that that doesn't constitute a new status quo, right? This is without prejudice, just to try to settle things outside of the court system. Mm-hmm. And oftentimes, Margie, you and I know this, we get family professionals involved with the family to understand the conflict, improve communication, to really help prepare a plan, not only for the parents, but also the lawyers involved, if you're doing it collaboratively, in terms of what options might work best for this family. So you're generating options, looking at goals and interests, completely different than what you're doing in court with emotion, where you're taking an adversarial position, usually saying something nasty about the other side and their lawyer. So I think it's a great idea, and I'm certainly all for it. Did you want to add into that, Cindy, before we move on?
No, I believe you guys covered everything.
Okay, want to hammer out a couple quick questions here. One is there a plan in place for family courts to have a starting point of 50-50? No, the Divorce Act and other legislation focuses on best interests of the child. 50-50 was sort of a maximum contact principle that was done away with the legislative changes. This is kind of an important question. In case of domestic violence and kids involved, how can I protect my kids and contest a motion from the other parent for parenting time and access? You need to set out what your concerns are. Would you agree, Margie, in terms of your material?
Yes.
And talk about the domestic violence, right? How that's...
Yeah, and I mean, it's kind of difficult to, especially on interim motion, like a temporary motion, to provide that sort of evidence. When you're at a trial, you have, you can cross-examine people, you can have experts, but an interim motion is kind of like, it's based on affidavit evidence, and oftentimes they're conflicting, contradictory, right?
Yeah.
So the best way to do that, I find, is to, some lawyers might disagree with me, but I find that it helps me in my cases, is to get as much evidence from other people about really bolstering why your plan is better, right? Try to steer away less. You have to go into what the domestic violence is, but really don't use the domestic violence situation to sort of paint the other party as bad parent, good parent. I find it helps when you try to tell the court, this is why my plan is better. And one of those reasons is because there is domestic violence, right?
And there could be other information already available, right? Through police reports, children's aids,
doctor's letters.
Right, recommendations from professionals, even what teachers or school officials are observing as well in terms of the children's behavior. So that goes a long way. The second part of that question was a really good one too. So the kids are saying, voicing a concern and don't want to be with that parent. We have a whole live event series just on the voice of the child and the age that the children's wishes should be looked at. So we'll refer that person to that resource. Final question I want to get to, somebody's concerned that the father who has status quo isn't going to do well in court with the mother. The plumbing doesn't matter. What the court's concerned about are parenting plans in the best interest of the children. So this idea of a 10-year years doctrine where children should be with their mother from 30 or 40 years ago, I don't think carries much weight. It's more who's got the best parenting plan. So there's bad things we need to talk about too. So let's get into that. This can be you, right, Margie?
Yes. So we touched upon exclusive possession earlier, but just as as we said, married spouses have an equal right to possession and to reside in a matrimonial home after separation, and that's regardless of who owns the home, unless the court makes an order granting one person exclusive possession of the matrimonial home or the parties agree. So first of all, this equal right to possession of a matrimonial home, regardless of ownership, means that one spouse cannot change the locks of the matrimonial home. This changing of locks of the matrimonial home is a common question that we get. We got that today, and it's an example of self-help, and don't do it, okay? Don't do it. If your facts warrant exclusive possession, then you need to go to court and obtain an order for exclusive possession. And now, obtaining an order for exclusive possession is not an easy task. Because it means that one spouse has to move out and find someplace else to live. And so in order to obtain an order for exclusive possession, the courts will look at both parties' financial situations, if there is other suitable and affordable living arrangements that could be made for the partner or party that's leaving, if one partner has been abusive towards the other partner or the children, and if there are any existing court orders or written agreements between the parties. So if there are children, the courts would also look at the best interest of the children by paying special attention to how the move might affect the children and the child's views and preferences or wishes if it's appropriate in those cases. So if you get an order for exclusive possession, bear in mind that you might also be responsible for occupation rent to the other party. That's permitted under the Family Law Act. And you will be required to pay the utilities that you alone use.
All right. You know what? We haven't done a poll for a while. What do you think? Let's get into a poll and we're going to do some more Q&A. So what's considered leaving the jurisdiction? I think lawyers going to float this idea around without really explaining it to people what jurisdiction means. It can mean different things to different people. So let's see what our audience thinks. And while we're doing that, let's get to a few more questions from our audience that are coming in online, which are excellent. Thank you, everybody, for sending in your questions. All right. Let's see which one we're going to pick up here. How soon is it to introduce a new spouse outside of the home to the children while in a nesting agreement? It's not, that's an important question, right? especially if you're looking to get a contact or parenting time order. Who wants to take that one? What do you think, Margie? New partners?
Oh, new partners. Oh, new partners. I thought I said new parent. I thought that was.
Sorry, I think it's a new spouse. Or
a new
partner.
spouse.
Well, you're nesting with the children, and I guess the former spouse is nesting as well.
Okay, so I've had this question a number of times, and I've actually had in a case where we consulted with an expert on child psychology, and what that person said was, oftentimes would want it to be we want the parent who's introducing their new girlfriend or partner or boyfriend, whatever the case might be, to the children. They should make sure, first of all, that the relationship is one of permanence, something that they feel is a serious relationship. And a serious relationship is often defined as one that has lasted at least 6 months.
Yeah. Somebody you met online last week, right?
Yeah, exactly. You don't want to expose the children to like a revolving door of girlfriend or boyfriends, right? That's not in your best interest.
Yeah, good comments. All right, one more quick question, then we're going to get to our poll results. Will an order for sale and partition of the home qualify as urgent under the current economic conditions? Well, the economic conditions 2 months ago, we're getting multiple offers on a house. Yeah, some people today, the economic conditions are that houses aren't selling as quick. So I don't know, Cindy, Margie, I don't think that would qualify as urgent. What do you guys think?
I think it would depend on, is the other party frustrating the sale of the home? Like, does the court need to get involved and say this party no longer has to consent to the sale? Right. So I think it would really depend on what's happening. Margie?
Well, piggybacking on what Cindy said, it's also, I think, depends on the financial, if it's a dire financial situation, right? If the sale of the home is required because one person needs to access their equity in it, and it's been too long, and they would suffer a financial, dire circumstance, and I think that would be an urgent issue.
Right. My gut reaction to this would be, I think a judge would tell you to case conference the issue before a sale would be considered. And maybe if it's available in your jurisdiction, to get an urgent case conference date. Really, the only urgency would be if you need to access your capital for some financial reason to buy another home or to meet your living expenses. Kind of an interesting question. So thank you for that. All right, let's see what our poll results are. Leaving the jurisdiction, majority is all of the above. So moving to another country, moving out another province outside the jurisdiction of the court. Jurisdiction of the court is kind of a funny thing. Usually that's usually a 2-hour drive, right? For most courts would be the jurisdiction. It'd be longer if you're up north. School district, only 2%, 50 kilometers away. All right, so what's the answer to this question? Could be either of them, right? But if you're leaving, I guess if the move is going to affect parenting time in some meaningful way that's already been established, then that's going to trigger likely the ability for the court to step in. What would you think, Cindy?
Yes, yeah, I would agree. If it's going to impact parenting time of the other parent, then you have to act. You have to act quickly to make sure that doesn't happen.
Margie, thoughts?
Well, at jurisdiction, when I think of the word jurisdiction, leaving the jurisdiction, yes, it's leaving the children's primary or habitual residence, where they're used to living day in and day out.
Right.
And yes, if it impacts, especially if it impacts the other parents' parenting time, especially if there's an agreement or a court order.
Or schooling even, right? If you're moving them out of school district, that could be significant as well.
Yeah.
Okay, so let's get into the ugly. Cindy, ugly sides of self-help.
Yeah, so every parent's worst nightmare. What if your child goes on vacation and doesn't come back? What do you do? So let's assume for the purposes of this presentation that your child's habitual residence is Canada. What you would do depends on where your child is being held. So if the country is a signatory to the Hague Convention of Civil Aspects of International Abduction, the Hague Convention, that opens up another process to you to facilitate the immediate return of your child. So that process does not deal with issues of major decision making. It's just return of child to where they normally reside. So in order to qualify for this process, both countries have to be a signatory to the Hague Convention, and your child must be under the age of 16. So if you're going to partake in this process, you're going to be contacting a special body created under the Hague Convention here in your country. And here would be the Central Authority of Ontario. So the Central Authority would be kind of like the middle, the liaison between you and the other country. And they would work towards having the child voluntarily return to Canada. Or if that's not possible, then a court application would be, a Hague court process would be commenced in that foreign jurisdiction, and you're going to be needing to retain foreign counsel. Now, there are certain circumstances where a foreign court can refuse to return the child. And some of those circumstances are you've waited for more than a year to commence this process, you acquiesce to the move or the retention, there is a grave risk of harm of your child being returned to you, or you don't have rights to custody, or you never exercised rights to custody at the moment that your child was withheld or didn't return, or your child is of the age and maturity and they have articulated that they do not want to be returned to your care. Now, these exceptions do have a limited interpretation. The courts are not going to go out of their ways to find, they're not going to go out of their way to say you fall under one of these exceptions. Now, what if your child was taken to a country that is not a signatory to the Hague Convention? What are you going to do? Well, you're going to be contacting the local police. You're going to have them ascertain the whereabouts of your child and also their wellness to make sure that everything's all right. Then you're going to be taking that information and you're going to be going to the RCMP. The RCMP has a special database that they share with their international partners. So your information will be uploaded there, and hopefully those international partners can assist in facilitating the return of your child. Then you're going to be contacting the Canadian Consulate. So the Canadian Consulate can provide you with information as to what to expect when you're dealing with this foreign country in this type of situation. And they may also have foreign counsel that they can recommend. And then you might also need a Canadian lawyer. And that depends on if you have a valid court order that states, that describes your rights to your child. On the next slide, we talk about what are some preventative measures so that you don't end up in a situation like this. Well, time is of the essence. There are new provisions under the Divorce Act that state if a parent is going to relocate with your child, they have to give you 60 days notice. And from that time, you have 30 days to object. Now, you object by commencing a court proceeding. So when you receive this notice, don't sit on it. If you plan to object, retain a counsel right away and start your objection. The other thing there is that if you have serious concerns about your child not returning, going on vacation, not returning, then one of the things you can do is say, you know what, I'm not going to allow my child to travel to a country that's not a signatory to the Hague Convention, given the difficulties that you are going to have trying to get them to return. You're also going to be trying to obtain, well, you should be obtaining as much information as possible as to where your child's going to be staying and who the other family members, where they're going to be staying, who the other family members are in this jurisdiction. Because most of the times, those family members are going to be facilitating the voluntary return of your child. Now, there are also some passport controls that you can explore. In Canada, you can contact the passport office and let them know that you have concerns about your child being removed from the jurisdiction or being abducted. So what they will do is register your child's information on their system so that if there's a new passport application being submitted for the child, they're going to take extra precautions. This does not invalidate any current passports that the child has, but it's an additional level of security. And then we have, if your child has a dual citizenship, you can contact the foreign consulate and request that they don't issue any visas or passports to your child due to the following reasons. So you are going to need counsel at that point to draft that letter there. In situations like that, the foreign consulate might not abide by your request, but it is a tool available to you. I believe we have a poll next.
Yeah, okay, just a couple questions coming in on either, are there, I guess with respect to the objection, even going to court is one way to do it, but put them on written notice as well. Either the lawyer or the other spouse say, I object to you relocating little Johnny to wherever. And you can rely on that. And then one of the questions is, are there exceptions to the notice provisions in the legislation? I think the judge has discretion to lengthen and shorten the notice provisions in some circumstances. And if you look at the Divorce Act, there's some forms there I think that will be helpful. So here's our final poll of the day. Thank you everybody for participating. After what you've learned today, is self-help a good thing or a bad thing? I guess depends. If you're doing the self-help or not doing the self-help might inform the answer, but let's leave this up for a minute. Question for you, Margie, that also came in ahead of time. Thank you, everybody. What is the status quo if there's been no agreement or court order in place after separation? We've been separated for 2 years and have one child together. Good question. What's your answer?
Well, I'm just going to remind everyone about my analogy of the cement. So if your ex-partner, the other parent, has acquiesced, has basically done nothing to state that he or she does not agree with this arrangement whereby the child lives primarily with you, and based on the question, it's been like 2 years. I think that person can be found to have acquiesced to that arrangement, and therefore the status quo would be what you have in place today. The status quo is a factual arrangement, right? It's not always a date of what was happening at date of separation, but it could be, for example, like in this situation where this has been in place for 2 years post-separation, that is now the status quo.
Yeah, right. One parent leaves the home. The other parent, whether it's the mother or father, is caring for the children. And it's been 2 years. I think you've created a new status quo, right?
Mm-hmm.
All right. Thank you for that, Margie, and for sending the question in. Let's take a look at our results. So what you've learned today is a good thing or bad thing. 71% says it depends. Isn't that Law School 101?
Yeah.
Golan was going on about that last week when they were asking, it depends, I don't know. 13% bad, 9% good. I think that's probably the correct answer, right? Depends on the facts.
It depends.
Before the court or of that particular family. Would you agree with that, Margie?
Absolutely. It's so fact specific that every case will be determined based on its own merits and its own facts.
Right.
Not one size does not fit all, especially when it comes to parenting issues.
And we have some cases that are going to talk a little bit about how self-help has been treated by the court. Cindy, good thing, bad thing? You agree? It depends.
Law school answer, it depends. It really depends on the circumstances. You might be required to do it, and other times you are going to be you're going to be surprised at what the court will say about your actions.
All right, thank you for that. Let's get into some case law, and then we're going to save some more time for Q&A. Thank you everybody for submitting your Q&As throughout the program. You still have time to send in your questions, and we'll try to get to as many as we can. So first case, I think, is mine, NVF. this is an interesting case where there were young children under 5. They were living in Dubai. Mom comes home with the kids for extended summer holiday and keeps them here. Goes to the Ontario court, says, I don't want the kids going back to live with their dad in Dubai. So this has gone to the Court of Appeal. Court of Appeal said, send them back. Dubai is going to decide custody and access based on best interests. Mother sought leave and obtained leave to the Supreme Court of Canada that has ordered an expedited hearing of the matter. And I think we're going to be getting this decision any day. So it'll be spot on what we're talking about today. Mom did self-help, kept the kids here from a summer vacation, says don't send them back to Dubai, have lived in Dubai with their dad prior to that. Ontario Court of Appeal says they go back. Supreme Court of Canada may change, may disagree with the Ontario Court of Appeal, and we can get some interesting case law around self-help. So look for that. It's coming down the pike real soon. Clement, I think this one, oh, sorry, there was another case I threw in here just for some fun, because we can't all be serious all day. So these two MJ v. TJ cases involves an East Coast decision and a court order and agreement regarding dog visitation. So we're not talking about children. And the facts are kind of interesting. It includes a refusal to return the dog. You know, we laugh, but dogs and cats are huge, right? Like these are like children for some families, and very, very important issues. Most courts treat them as property, not setting up parenting plans for the pets. But this particular case, there's a refusal to return the dog. It involved a fake dog's death certificate, procedural wranglings, and contempt of court. So if you want to have an interesting case to read, I'm throwing that out there just for some fun. And I think we have some more serious cases. Clement, this is your pick, Cindy.
Yeah, this was my pick, and I chose it because it stands for the proposition that a parent who engages in self-help, despite the best interests of the child, calls into question their own parenting skills and judgment. In many cases, courts can conclude that these spiteful, selfish, manipulative parents can't be entrusted with the custodial arrangement or custodial authority because they might abuse it. So in this case, the children had essentially an equal time sharing arrangement. The mother became annoyed with something that the father did. She got the police involved. The father was charged with mischief because he left some property on her doorstep that was hers. And then she read into that to say, you know, you cannot, all your access has to be supervised. She removed one of the children from the school, kept the child home because she was afraid that the father was going to take the child after he found out what she did. And then she registered the child in school in her city. And she brought up a whole bunch of allegations against the father that were historical and not proven. And the court found, you know what, you can't have custody of your children anymore how you used to. And they gave the father temporary custody of the children, and the mother only saw the child on the weekends, every other weekend.
Yeah. You know, I'm just thinking about your comments, you know, habitual residence, that concept is so important to self-help, right? Because we see parents who take kids out of province, whether it's East Coast or West Coast, and commence a court proceeding in that other jurisdiction. And now we have a battle over jurisdiction where the kids habitually reside. So timing is really important, right? If it's within a few days or a few weeks or even a month, the original jurisdiction, I think, would have habitual residence. But if you sit on your hands for 2 years, right, and the children get established out west, that's going to be a hard argument to say, you know, they haven't created a new status quo. All right, Corbett, or correlate. This one's yours too, Cindy.
Yeah, I included this because I wanted to highlight that there could be significant cost consequences if you engage in self-help that is not warranted or justified. So here we had a father who went against a consent order that detailed, the kids' environment, their status quo, and what to do if there was an issue with respect to what to do if they requested a change. So the father completely ignored it. He said he was taking the kids on a 2 to 3 week vacation in Florida. While he was there, he refused to return them to Ontario, and he then enrolled the children in school in Florida. So the court found that the father deliberately violated the court order. He caused enormous distress to the children and significant stress and expense on the mother, who had to bring an urgent proceeding. Then the court had to take the stance that they could not condone or encourage this type of self-help. And they ordered the father to pay a greater proportion of the mother's costs to bring the emergency proceeding, and it had to be payable immediately.
Before we get to Margie's case, what we do, just think a hypothetical situation. Let's say because the court orders aren't suggestions, right? They need to be followed. It's not a recommendation, it's not suggestions. You need to follow a court order. But what about the family who has a parenting and contact order in place, or the old language custody and access, but they haven't been following it for 3 years, right? It may have said kids are going to be with dad, but now the kids are with mom, right? And then you get 3 years later, dad says, I want to enforce the court order. That's not really self-help at that point. Would you agree? Because they've created a new status quo, even though it's contrary to the court order, and the court order hasn't been updated. It doesn't reflect what was happening back at home. What do you think about that scenario, Margie?
I think that we see this a lot, and I think one of our associates here had the same case, something happened similar in their case. I think there is a new status quo, right? Just by the passage of time and an acquiescence on the other parent's part. They're content not to follow the agreement and allow this situation to continue for 3 years. I think from a court's perspective, the agreement is not completely irrelevant, but I think they're going to look at what is in the best interest of the children, and that's maintaining the stability that they're used to for the past 3 years.
Yeah, I agree. Blake versus Ray's final case of our presentation. You, Margie, I think this one's your pick.
Yes, I chose this because this is an example. We were talking about in the earlier cases about breach of a court order. This is a situation where a judge actually, clearly said that she didn't condone the mother's self-help actions, but in any event granted what the mother wanted. And this is a very specific sort of situation. So the parties had been engaged in very difficult litigation over their 13-year-old son for most of his life. There had been 2 trials and 45 court attendances or events since the original trial decision. And there was a court order granting the mother sole decision-making and a week about residential arrangement with the father. The mother subsequently brought a motion requesting an order permitting her to relocate with the child to Kitchener. She was unsuccessful on that motion. 5 years later, she again brings a motion, again requesting to relocate with the child. And while the motion was pending, the father was charged with assaulting the child. In response, the mother then breached the court order and relocated the child to Kitchener, which is contrary to the very specific terms of the order that the child was to reside in Barrie. And so at the time that the motion was heard, the mother and child were living in a shelter in Kitchener. So although the judge was very troubled by the breach of the court order, and she found that there is absolutely compelling circumstances justifying the mother's self-help actions, and based on that facts, the judge was satisfied that the best interest of the child mandated that he continue to live with his mother in the Kitchener-Waterloo area. And what helped in this case was that the mother's lawyer brought a motion to change as soon as possible and conceded that she was in breach of the court order and that she prepared to accept any sort of penalty that the court found saw fit to impose on her for breaching of the order. So this case was not to be read as the court sanctioning or agreeing with self-help. Justice Waldman goes on to some distance to make that clear. It does, however, stand for the proposition that there are sometimes very compelling circumstances which would justify a breach of a temporary court order and, self-help. So that's why I picked this case.
Important case. We spent an hour on that case. So all these cases are going to be provided in our show notes, but let's wrap this up. Here's our host, right on time. Welcome back, Shannon.
Thank you. Thank you to the three of you for all of that very useful information. We hope that everyone enjoyed. We just want to thank everyone for your participation today. We got a lot of great comments and questions that came in. We're going to try and sneak maybe one more question in, but just quickly before we sign off, just wanted to let everyone know just as a sign of our appreciation, we wanted to offer a complimentary e-copy to those who fill out the survey. There'll be a survey that pops up in your browser following the webinar, just asking for some feedback on today's presentation. It's very important to our team, just allows us to continue to grow our series. So if you have the time, we appreciate and welcome any feedback you have. And we did try to get to a lot of questions throughout the presentation, but just a quick question that came in advance I'd like to sneak in here would be, what if the parent abuses drugs? Is my first step going to court to limit their parenting time?
Depends, right? It depends. It depends if it's marijuana, maybe not. If it's a harder drug that's going to affect the ability of that parent to parent, certainly. Quick answer, Cindy, what do you think?
I agree with it. It depends, but it can be an opportunity to negotiate an interim agreement while that other parent gets help and to safeguard the child. So that would be my response there.
Good answer. We've got 1 o'clock, Shannon. Fantastic work as always.
Thank you. Thanks again to our panelists, and thank you to all of our audience members who joined us today. As I mentioned at the beginning of the presentation, just keep an eye out for a follow-up email tomorrow that will be coming from us, just with, as Russ mentioned, those case laws. So we'll have the links to those cases if you'd like to take a deeper dive into those. And if you do have any questions about our virtual event series or any comments for our team, please feel free to reach out to me at shannon@russellalexander.com. And just to note that we do host our virtual event series bi-weekly on Wednesdays at 12 p.m. on a variety of family law topics. And our next discussion will be on Zoom divorce for clients and the modern lawyer. And that will be on Wednesday, June 29th at 12 p.m. But I'll be including a full list of our upcoming webinars as well in that follow-up email. So just want to thank everyone again, and we hope you all have a wonderful day.
Great job, Cindy. Thank you for your time. Margie, thank you so much. Shannon, perfect as always. Really appreciate everybody showing up today.
Bye.
Have a good afternoon.